Lemooriya Tharsina. I'm from the Family Law Department of Ramachandran Law. Today I have Tharsina with me from the Wills and Estate Department of Ramachandran Law to discuss how family law and estate planning interact with one another, and specifically how estate planning comes to play in when you're married, when you're separated, and when you're divorced. So welcome, Tharsina.
Thank you.
So Tharsina, what happens when two people are married to one another and one spouse unexpectedly passes away with or without a will?
Okay, so whether you have a will or you don't have a will, you have to take into consideration that there's something called preferential shares, which basically means the spouse is entitled to the first $350,000 of the estate, in addition to a portion of the remaining assets. So let's say in the will, the person dies and there's a will, and they say, hey, my wife is only getting $250,000. So the wife or the husband, actually. So in the event, you can say, hey, I don't want the $250,000 because there's more assets in the estate. You can go with the preferential shares, which means you apply to the court to get the first $350,000 of the estate, and then you'll get another portion of the remaining assets. So that's actually a choice that you can choose as a surviving spouse.
So even if the will, like I'm a spouse and I say in my will, I want 1/3 of the property to go to my wife and the other 2/3 to go to my children. Even if I put this in the will, someone can choose not to follow the will after I pass away. Is that how it works?
Yeah, pretty much, because regardless of what you put in the will, the Family Law Act actually dictates who is going to get it. So let's say in the will you write that my wife gets 1/3 and my two daughters get in the other 2/3. But she can go to the court and now say no. And let's say the property is worth $500,000. So it's like saying she gets only 175. She can go to the court and be like, hey, this property's worth 500. I want the 350,000. And then she'll get the 350,000 off that. You have 150,000 left, and then that 150,000 will be split amongst three people, so the two daughters and the wife. And that's how that would dictate. But it also goes down to then how the property, the matrimonial home was registered. So if it's registered as joint tenants basically means in the event one of the spouse passes away, the other surviving spouse automatically takes ownership and they have title to the property.
Okay.
Whereas if it's tenants in common, when you're registering a certain percentage. So whatever percentage is left over, you would have to pay a land transfer tax on it, and you will become the full owner of the property on title. But if you're legally married and as a matrimonial home, you are exempt from paying the land transfer tax.
Okay, and just to clarify, a matrimonial home is basically any property that you live together with your spouse. You reside as a primary residence. So if you have multiple properties, but you only live in one primarily with your spouse, that property is a matrimonial home. And you're saying that property is the one that would be exempt from land transfer tax.
Just to elaborate a little bit more, so the matrimonial home would be exempt from the land transfer tax, but any additional investment properties that you do have and you need to now transfer that onto your name, you will be paying 100% land transfer tax on that.
So how does this work? This process that you described is when two people are married, one spouse dies, and now they have to go through the election, preferential share, and then the matrimonial home comes into play in land transfer tax. So what happens when two people are separated but they're not officially divorced? And this is a common problem that people come to our office for due to maybe religious reasons or cultural reasons, or for whatever reason. They may choose not to be divorced, but they may live separate and apart as separated parties. And we know in the eyes of the court, two people, whether or not they're separated, unless they have a divorce, they're still legally married. So what happens in these situations?
So again, preferential share still overrides the will, just because whether or not they're living separate and apart, in the eyes of law, they're still legally married.
Okay, so this seems like a problem. So what can we do to mitigate, or what can people do out there to mitigate these? Like perhaps they don't want to give 350,000 of their assets to their spouse or they're separated, their ex, right? They may want to give it to their children, their aunts, their parents. So what can we do to prevent preferential share from happening, or is there anything we can do? Is this just how it is?
Well, first of all, if you're deciding to separate, you should have a separation agreement. And you can elaborate, I guess, a little bit more on what specifically put in a separation agreement for it to actually be used in the estate court in the event that it does go to litigation and you are fighting with like your ex, for example. But so a prenup or a separation agreement, or just get legally divorced. That's what you choose to do, right? Because honestly, a lot of people, I think, especially I think the South Asian community,
Yeah.
I do feel like people don't do it for a specific reason. Maybe it's, what the society thinks and stuff. But on the long run, especially with us, we've actually had clients
Yeah.
who've been in the situation. And when young children are involved and when there's a lot of money involved, it could get really, really messy.
Yeah, and do you want your spouse or your ex-husband, your ex-wife, who you may have had a really bitter breakup with, do you want this person getting 350,000 of your assets? Do you trust them to divide these assets amongst your children? And do you want them deciding your funeral arrangements and stuff? And we've actually had cases like this, right?
Yeah.
Where people, husband and wife, they may have different religions, right? Religious beliefs. One believes in cremation, the other believes in burying. And we've had situations where because they're still legally married and they're not, and they're just separated, but they're not legally divorced. Now you have a bitter ex planning your funeral arrangements and planning, what to do with your assets. So yes, separation agreement. So often people will ask, what's the difference if me living apart is the same as being separated? Why have a separation agreement? And the reason being, in separation agreements, we'll actually have a clause in there that says, I release, I have no right in the other person, this other person's estate, and this person has no right in my estate. And we put that as a clause, and depending on what your relationship with that person is, you may file it with the court, or you might just save it, store it somewhere safe. And storage is also a big issue.
Yeah, because we've had an incident where the prenup and the separation agreement, another one where it wasn't stored properly, and we didn't have a copy of the original, which meant basically that the ex was able to use that to his advantage to basically fight off important rituals from happening during the funeral. And so storage
time.
Yeah.
And then a lot of people don't understand. Okay, so you have a will. Let's say we're following the will, and the will will say, oh, I prefer being cremated, or I prefer being buried. And then you say, okay, this will has been signed, prenup's been signed, separation's been signed. I'm going to store everything in the bank deposit box. So why is this a good idea?
The reason why it's not a good idea is because let's say the person passes away and their separation agreement, prenup, or their will, or any legal document is in the safety deposit box. They don't have access to it. For them to even start the probate application to become your estate trustee, they need the actual will. And if you put your funeral arrangements, of course, when you're writing the will, you do put your funeral arrangements in there. If it's in there and they don't have access to it, they're not going to know what you want to do.
And are they going to wait a couple months to figure this out? No. They're going to try to cremate, especially depending on your religious beliefs. You may want to cremate within a certain period of time. You're not going to wait to find, okay, I need access to the safety deposit box. Okay, send it to the bank manager. Okay, I have access. There are a few ways that you can get around this. If you have a bank deposit box jointly with someone else and that person's still alive, obviously they can access it, provided they haven't also passed away with you, right? Mm-hmm. And then I think the best way to store wills, prenup, separation agreements then would be somewhere accessible. Tell a loved one that you trust where it is. Fireproof, waterproof, have backups, and that's how things should be stored, right? Safety deposit box is a terrible idea.
Yeah. You can put your original in the safety deposit box, but you should at least have a true copy where it's accessible to somebody that,
tell them where it is. Don't hide it underneath your mattress. No one's gonna find it.
Yeah, because it's one thing about getting it drafted, getting it, witnessed and having it done. But there's another thing about having it accessible when it's actually needed.
Because oftentimes these things happen years afterwards, right? If you're doing a prenup or you're doing a will and then you get married and life goes on, by the time you're actually looking for this, it might be 20 years later, the witnesses may have also passed away. You need to keep it safe, somewhere accessible, and you have to tell someone where it is.
Mm-hmm. And not all law firms, or let's say the lawyer who drafted for you or witnessed it, they don't keep hard copies. They don't have the original.
There's a 6-year limitation, a 6-year period where they're like, okay, we're allowed to destroy this. Unless you give them specific instructions, don't rely on your lawyer 20 years ago to still have their office open, still have the lawyer alive and pretty much knowledgeable of where it is, and have a hard copy for you. That's your responsibility, right, after it's been signed.
Yeah.
Okay, so we looked at what happens to your estate when you're married and your spouse passes away. What happens to your estate when you're separated but not legally divorced, and your spouse passes away, or your ex passes away, and you're saying obviously a will is not going to help this situation at all.
Yeah, and also another thing to note is with preferential shares, it's something that you have to do 6 months from the date of death. So you have
Okay.
until 6 months after the date of death to, apply to the court for this to happen.
Mhm.
If you proceed, like if you pass that date, of course, I'm sure there will be some exceptions, but that's the cutoff. As well as if you're a surviving spouse, you also have 6 months from the date of death to do a spousal election under the Family Law Act to say I'm the surviving spouse and I'll be taking this stance.
And I actually just want to clarify this one point about prenups, right? Because we've had a case where a prenup was done, bitter separation, a divorce application was done,
But not finalized.
because, COVID, all our divorce applications that we submitted in the beginning of COVID, they're just coming in now because there's just huge delay, right? Staff were working from home, things were a little slower. So we've had situations where even with the prenups aren't foolproof. And prenup, another way of calling a prenup that we commonly use here in Ontario is actually a marriage contract. And marriage contracts are not foolproof, right? You need to cross your T's, dot your I's by making sure like there's copies accessible. And in this situation, this person didn't have the copy, but we knew, right?
Because it was like a picture of of the original. It wasn't even an actual
Yeah, we've
copy
had
that
this so many times where people just
Yeah.
have photographs.
Yeah.
That's not good enough, especially with Photoshop. That's not sufficient, right? And another thing that happens often, right, where people have multiple wills, right? So they get separated, they'll have another will, maybe they have another child, so they'll have multiple wills around the house. So what happens there?
So one thing that we do in our firm is we intertwine our departments. So like, for example, when Lemooriya is done with a client and she's closing off whether they got a divorce or separation agreement, she does a referral. She refers us to the wills department. Maybe now it's time for you to either write your will or update your will. So we always recommend to clients, in the event a major life-changing event happens in your life, revisit the will, because you might be married, you might
Have another kid.
yeah, you could have more kids. Like, let's say you have a surprise baby and then you didn't include that baby in the will, and like you pass away, and as sad as it is, they don't get anything because they're not in the will.
And people change. Like,
Yeah.
you might think, oh, well, it's my siblings, it's my parents, my children. They're going to be, we have a good relationship, it's going to be good, but people change, right? Especially years later when the event actually happens, right? It might be 20 years down the line and people might not have the same sort of bond and relationship. And, when there's a lot of money on the table, right? If you're looking at, properties, multiple properties, and like thousands and thousands, hundreds of thousands of dollars, you can't expect people to be so virtuous and say, okay, well, I know my mom and dad wanted my baby sister, and like you
Yeah.
have to plan for it.
Yeah.
It's the responsible thing
Yeah.
to do.
Because of course we're all thinking, hey, everybody gets married once, you
Yeah.
have your kids, you write
That's
this.
not life anymore.
Yeah, exactly.
Right?
And
People
like
get married multiple times.
times.
People have children of one marriage and then children of another marriage. Like, how do you sort this? And that's actually a question I wanted to ask you. So let's say you have you have children with with a partner. You get separated, you get divorced. Now you're married to another person. So what happens? Does a new spouse get preferential share, and do they get to decide, even if you have a will, do they get to decide whether the assets are given to your children from your previous marriage? Like, what happens with that?
Well, it really depends on what. So like an example would be, I'll give you a real life example. There was a client who had a will which was written about 20 years ago or so, and he's now on his third or fourth marriage. Not exactly sure. And at that time, he wrote that a certain amount of shares is going to go to his kids. But then throughout the years, the matrimonial home now, which he put for his kids, he had to bring on his third wife onto the property. So, and they're registered as joint tenants. So when he passed, the property automatically goes to the wife, regardless of what the will says, regardless of what the preferential shares will indicate. As per the real estate law, the wife is now the owner of the property, although the will says it's for the kids,
to the children. And this happens quite a bit, right? And then depending on how the relationship between the spouse and the previous children are, it might be okay, something that you can resolve between families. It might not be okay if it was a bad breakup and the children don't like the mom and whatever. But isn't this something that you'd want to decide before you pass away? I think the biggest thing is, you don't want your family members, your loved ones to be fighting over your assets or fighting over your funeral arrangements after you pass away. I think the responsible thing to do is being, okay, this is my funeral arrangement, my assets. I want to leave it this way, and I'm made the responsible choice to make arrangements to leave it this way,
Yeah.
right? And that way you don't have your loved ones fighting over, like your funeral arrangements, right? That's such a terrible thing.
I know a lot of people don't think about it. They don't want, they're like, hey, I don't want to speak about the hard topics, or like, I don't want
Or
to think
I'm
about
so
it.
young.
Yeah, it's not
But
going to
life
happen
is
to
a
me.
guarantee.
Yeah, I do really think that in the event when there's children and there's assets involved, or there's multiple partners, multiple marriages,
Especially these days,
Yeah.
right? Because you have assets, but because of the real estate market, you have multiple people on these assets. You might have, you might just be on title for mortgage purposes, right?
Yeah.
On title for your parents who are elderly. So the responsible thing to do is sort out these issues ahead of time so nothing happens. And what we've learned in the last 2 years with COVID is nothing is guaranteed in life, right? You can be young, you can be healthy, you can be old, but we don't know what will happen in the future. You just have to prepare for the worst.
And that's actually very important. If you do write a will and then you update it or you rewrite it, will, usual terms law firms and lawyers use is, this new will revokes the previous one. But whoever you include or whoever you're putting as your estate trustee, or tell a loved one that there is a new will.
Yeah.
Because in the event something happens and nobody knows about the new will and nobody can find it, they're gonna go with whatever they knew about, like, from 15 years ago and what's on that. And let's say at that time you put it that your first wife gets the house, and then and the second one is like,
often, right?
Yeah.
You need to tell people when you update your will, right? And people don't like to talk about the will.
Yeah.
Maybe it's like, oh, I don't want to know which child has all the assets. Like, you're trying to make it hush hush, but you have to let people know. This is the biggest thing. So what's the takeaway, Tharsina?
Honestly, family law and real estate law, I think,
And estate law?
estate law and real estate, I think it all just intertwined with one another. I do feel like a lot of people don't have the knowledge.
Yeah.
And they don't realize it until it hits the roof. Like,
Yeah.
even for us, for example, did we know before we started doing this?
No.
Like,
No.
like, once I started doing estate planning, it's like, hey, I gotta write my attorneys,
my
I gotta
parents,
write
you need to get your wills done, because you don't, people underestimate what will happen in the future. Nobody likes to talk about morbid situations.
Yes, that's agreed. When when push comes to shove and they need the legal help, they need us to get involved, and most of the times it's actually very late by the time we get involved, where the damages can't be limited.
Yeah.
And honestly, like, it's not something that you want to speak about, you don't want to do, but
You don't
get
want
it done.
It's better to do it now
Yeah.
than after someone has passed away and now you're fighting over like the burial or ashes and whatnot. Like, it's better to deal with this now.
And I know you just think like, hey, it's a couple of $100. Why am I getting it done? Honestly, guys, spend the couple of $100 now. Get it done.
Rather than going through litigation where you're spending thousands.
Yeah. And legal fees are not cheap.
Yeah.
And it's, 20 years down the road, it's going to be even more expensive.
Yeah.
And you want to save your family members, your future grandkids. Why give them a hardship? Because what do you want them to mourn your loss or figure out how to
deal with finances,
Yeah.
And that's what estate planning is, right?
Yeah.
Pre-planning what will happen, pre-planning taxes, what will happen in terms of funeral, what will happen in terms of assets, who will get it, and making sure your loved ones don't have to think about this.
Yeah, like, speak to your accountants, speak to your lawyers, speak to your loved ones, get all these things done. It is very, very important. And like, even when we get inquiries, people ask like basic questions that, to us now it's like, hey, why is this person asking this question? But then it's like, hey,
it's not common knowledge.
It's not like, you would think that something that's so common is really not common knowledge.
Common knowledge.
Like,
and everyone dies in this world, but this isn't common knowledge.
Yeah.
Right?
And
no one lives forever, but this isn't something
tough.
that people know.
Guys, you can't legally leave your spouse out of your will.
Oh, yes.
Yes. Because I think almost one a day. Yeah. I'm not putting my wife or my husband.
I don't trust them. No. Then I think it's time to like.
Yeah. Then there's
break apart. If you don't trust someone. If you don't trust someone to the extent that you want to leave them out of the will, well, just know they're gonna get it anyway. So if it's really that big of an issue, I think this is probably something
that you need
more underlying.
Yeah. So you came for estate, but you're going to be going to family law. But it's like, even if you do leave them out of the will, they're going to be entitled to it.
Yeah.
and all they need is a good lawyer. They just need to know the law, and
Yeah.
honestly, they can they'll be entitled to it. So don't leave your spouses out. You can leave your kids out because, you know,
It's
that will be like next of kin. Let's say
yeah.
both the spouses are dead, then it'll go to the kids, and in the event the kids are not there, then it'll go to the parents, and then of course next of kin there'll be the siblings. But you cannot legally leave your husband or your wife out of your will. Don't try, because there's laws protecting them. And if you are deciding to get separated, or you know you are going into your second marriage, you know, make sure you're legally divorced. You have a a marriage contract.
Or you have a separation agreement dealing with this issue if you don't want to get divorced, right? And I know there's a lot of cultural connotations around divorce, but you can still pre-plan it. Get a separation agreement, put in a clause to deal with these estate issues.
I hope we shed some light on some important information with family law and estate. This is just the basics. You know, if you do require more information, we're always accessible. You can either email us, you can call us directly. We're happy to help. You know, we'll answer any questions that you guys may have. We do real estate. We do family law, estate,
civil litigation.
We even started immigration now.
Yeah.
So the help is there, guys. Just call us today and reach out.